So let's start off a little bit on the changes in 2024. So the big change for those of you who may not have been involved in the program was the introduction on April 30th of a cap. So each designated entity, effective that date, could only issue 10 certificates for the year. And when the year ended, December 31st, another set of 10 certificates were issued. In the past, there was no cap, which meant a designated entity could issue as many certificates as they saw appropriate to do. And this was really intended, again, to restrict the number of applications because we have a huge backlog. So that was a significant change, which resulted in designated entities having to rethink their business. In some cases, the cost went up because they had less volume, but a very significant change. The second point was a priority in processing. So IRCC came up with a new provision whereby if a particular entity, a VC or an angel was investing money, or for that matter, even an incubator, at least $75,000, then they would get priority processing, as well as if you were a member, if you're a business incubator and you were a member of Canada's tech network, those particular designated entities were also entitled to priority processing. So these were two significant changes. And these new provisions are valid until the end of 2026. These are not permanent changes. This was really designed to slow the number of cases that were filed and try to distinguish which cases should be processed before others. There's a list. You'd see that North Forge is on the list as one of the tech network partners. So these are the particular business incubators that have the benefit. And others, it would be dependent on whether or not they invest capital. So just good to familiarize yourself with that. There were also during this time, around April 30th and shortly thereafter, some clarifications on process. And these were very important because the reality was there was a lack of guidance. Keep in mind, these regulations were created in 2013 with the mind of a pilot, and they have not been significantly reviewed with minor tweaks in a substantial way, despite the evolution of the program. So these policy guidelines are very important, and we're going to talk later about some cases, and this is really important for everyone to pay attention to. For all applications, an officer must only accept updated commitment certificates until the receipt of the first SUV PR application from any member of the entrepreneurial team listed on the certificate. So if you receive a certificate, right, and that certificate is valid for 6 months, if any one of your members files that application, even if it's just 1 out of 5 people, no further updates can be made to the certificate, right? And that's very important because there have been issues in the past where we've been retained by individuals, and we've seen that there were 2 or 3 different certificates, and there were updates to the certificates, and people were added and taken off, sometimes a year later. This makes it very clear there's a lock-in date, right? And so once that first PR application has been receipted, it's locked in. There can be no further changes. If you're in a situation where you had changes, you need to get advice, because you'll see the federal court case law is very strict in its interpretation. Another beneficial clarification was that where an essential member has received PR in another program, let's assume that somebody in your team applied for express entry and was selected and became a PR. In the past, we'd seen cases where everyone was refused, but they've clarified that if all other requirements are met, officers can still approve the rest of the group before proceeding with the withdrawal of the applicant who applied for PR under another stream. So good to know if you have a teammate and they've advised you that they received PR, there should be a notice that you do, but it's not an automatic refusal. In fact, it can be entertained. And the last one is if someone passes away in your group, and with processing time, sometimes that's possible, then it's still possible for the individual to be withdrawn and for the rest of the group to be processed. So those are useful pieces of advice that came out as well in April. You now have a picture of 2024 where there are many of these new measures introduced. 2025 has a relationship. Now that the intake has slowed down, IRCC has released, and they actually released some of this information at the end of the year, that they would be introducing new regulations in the program, and they should be released sometime in the summer. And these regulations are designed to achieve really clear mandates. Firstly, to improve IRCC's oversight of designated entities. As you may recall, there was a third body, NACO, that was in charge of overseeing the designated entities, but there was a lack of detail and activity there. So IRCC wants to make sure that they know what the designated entities are doing, that they're meeting a certain standard, and that there is checks and balances. They also want to clarify activities that are not permissible under the SUV program. So there's a lot of practices that have occurred in terms of how different groups get selected, how businesses are presented, the roles of designated entities, the roles of third-party consultants. And if you look at the regulations, there really isn't any guidance on what is permissible and what isn't permissible. And that's allowed a little bit of a free-for-all in the marketplace. And so IRCC is aware of different practices, and hopefully what they'll do is provide guidelines in the regulations as to what is permissible and isn't permissible. And lastly, really to clarify program requirements more clearly. And as lawyers, we can tell you that officers are thoroughly confused in many instances about what the program requirements are and what's permissible. And there's information on the website and some information on the regulations, and in some instances there's information that's in neither, and they're trying to make sense of it, and it's become quite an unpredictable process. So I think this is a good initiative where when I talked with IRCC about 3 weeks ago, they said, in fairness, when we asked about motivation in the new regulations, they said there hasn't been any significant changes over 13 years to the regulations in a meaningful way. Whereas the program has really, as Nermeen mentioned, it's evolved. So it's time to catch up. And that's what we're going to see. And so I think when we look back at 2025, and by the summer, we're really going to understand what the new thinking is.
a very unique situation that arose a couple of months ago, and then it was repeated by another unique situation. Our firm was contacted by someone who was at the border. So this is a client who had landed in Canada after being approved on the Startup Business Class program by the IRCC. They had a confirmation of permanent residence in their hand. They had their passports that was stamped by the visa post abroad, and they were advised by their consultants that this is merely a rubber stamping process, and all you have to do is just present these documents at the border, and you will become permanent residents. Mind you, this is after waiting probably over 3.5, 4 years of processing under the program. So they land in Canada, they go to secondary of the CBSA to say that they are landing as permanent residents. And the CBSA officer raises some concerns. They ask them questions with respect to their business. They ask them questions with respect to the progress that they've made on their business. They ask them whether they have any bank account that's functioning currently in Canada. They ask them about, tax records. They said, have you been working in Canada? Please provide tax records. They asked them about other team members who've been working on the business, about their families, or what part of Canada they're staying in, and a number of different queries to establish whether the business is that they intend to establish is real. And they also wanted to check whether the business is established in Canada already. And so they reached out to us from the airport after having been grilled by the CBSA for between 3 to 4 hours. And I rushed to the airport. Noman and I had a very interesting conversation with the client, and I rushed to the airport the very next day because the client was called back again. And we stayed with the client for over 8 hours, in which the officer had questions over questions with respect to a number of different aspects about the business. Um, what we've come to realize now is that the client had made certain observations and made certain statements with respect to the progress of the business, and the CBSA was evaluating whether the information provided by the client to IRCC was correct information or not. CBSA was trying to evaluate whether the business was artificial, in the sense that whether the client had just created the business to avail permanent residency under the startup business class program. And these issues are arising, and they're very real, because just last month we faced another very similar issue with another client who was landing in Canada after being granted permanent residency by IRCC, and a similar issue arose for this client because they had contacted us at a stage where they were interviewed for one day, and the next day the officer had requested for certain information. We equipped the client with a comprehensive port of entry letter in which we explained how all the criteria of the startup business class are met. We also gave answers to all the questions that were raised by the officer in a written email, and we provided documentary evidence, and we were there at the airport to represent the client for any other issues that the officer may have. This time, this client was landed as a permanent resident because there was clarity of thought with respect to what questions were asked and what answers were needed to be given. The earlier client, unfortunately, had to leave Canada because of certain personal circumstances, and they had to withdraw their entry. But that case too, we are currently litigating before the federal court. In essence, what I'm trying to say is that even if your application for permanent residence is approved under the startup business class program, the process of landing is not merely a rubber stamping process. Even there, you have to be fully equipped. You have to be ready to answer any questions that are raised by the CBSA officer at the port of entry while they are landing you as permanent residents. And if at any point the officer frames an opinion that the answers that you are giving are fraudulent, fictitious, and the information that you've provided to IRCC is misrepresentation, then you may be stopped from landing and another process may be started against you.
Great. Thanks,
Yeah.
Pushkar. I think the point there is we can see that there is enhanced integrity, and your process is not complete until you actually have your PR visa completed. And it's really critical that you prepare in advance. You know, when you're in front of an officer and you're being admitted, you don't have counsel beside you. So you do need to have discussions. What we typically do is have a landing process. We make sure clients are prepared for all the different questions that they can be asked. You should have materials there that you can present, and you should appreciate that the information you provide can be used in making a determination against yourself. That's why it's really important that you do have good legal advice, because these processes are being scrutinized. Keep in mind, as I mentioned earlier, one of the big concerns was about artificial transactions. And so when cases were filed some time ago, officers at that time were approving cases without as much scrutiny as we see today. And so they can definitely take a second look, and it's important to be very careful. Moving along the same theme, Alif, you know, we've been talking for a long time when we saw the new employer compliance inspections roll out, and we've seen this in the corporate world for employers of temporary foreign workers. We saw it being released in the startup scene. Why don't you give us a sense of how that process works and how, again, along the theme of enhanced compliance, how it's evolving in terms of the form that it's taking?
Sure. Thanks, Naman. So, as mentioned, the employer compliance inspections, they kind of came to rise within the last 2 years or so. And typically it was geared towards the issuance of the work permit. So the basis for the inspection was, is this worker actually working for the company? Where are they working? What's the location? Are they being paid in consideration of the offer of employment that was submitted before IRCC. So there was a number of checks and balances that were put in place. And that was the previous regime. So now we are actually seeing a bit of a change and a shift where things are becoming a little bit more tightened. So there is a bit of a stricter employer compliance regime right now. And so previously they were asking for very high level things like, what type of work were you doing? What's in your job duties? What's your description? What role are you performing in Canada? And they would ask you questions about your physical work location as well. So those are very common. It was more so about the employer-employee relationship. But under the SUV program, there was a bit of a nuance because the employer is also the employee. So they both were the same person. And so a lot of those questions we were able to handle fairly easily, as long as you could show activities, you're actively involved, and you had documentary evidence for everything to back up those claims and that information. And so that was the previous employer compliance inspection. But what we're seeing right now is an enhanced version of that. So this is actually a list of everything that was requested previously. So incorporation documents, your business license, CRA, tax documents, financial statements, invoices for clients, bills paid, lease agreements, and other engagements with companies or contracts with other customers even. The last point is all relevant information to show the officer that you're actively involved. That was kind of a catch-all. And so all of this kind of still remains true, but the enhanced aspect is the new on-site inspections that we're seeing. And so typically you get a notice saying that there will be a inspection that will be held on site for the address that you've listed in the offer of employment. If it's a virtual office, they may just end up making a meeting with you at a desirable location, maybe the incubator's office, maybe in IRCC's office. It's not really clear where they would do so in a virtual setting, but they typically give you notice that this inspection is happening. However, the officer could actually just show up and complete a site visit with the employer and employee. So they may come to your office, they may say, hey, we're from IRCC, there's an inspection taking place, can we have a moment of your time? And when I say a moment of your time, the actual timeline, it could be up to 2-3 hours that this inspection may happen. And the interview process is very rigorous. The officer is going to ask you a number of questions about your activities. In this list over here, they also ask about your business idea, what kind of clients you have, what type of business you're operating, what your business plan is. And they could also ask about how you're funding the operation, what kind of expenses you have, what transactions have you been making. And then that's all in addition to the previous compliance questions that they had. And so the purpose of these inspections is to ensure that there is integrity in what you're doing in the business. And it's to ensure that these startup companies are legitimate. So it's another layer of validity that's being put into place by IRCC. And there could be a number of things that the officer asks about. They can even ask about more compliance-related questions, such as who created your business plan. This is a very hot topic right now because it looks like the officers are becoming more knowledgeable about the different methods that these startup companies may have for creating a business plan. One key thing to know is that if the officer believes that the business plan was maybe created by an entity that maybe shouldn't have created the business plan and the founders had nothing to do with it, then it could negatively impact your PR application. These officers, they make very detailed notes, and they put all of these notes on the file for your PR application. And it could also have implications on your work permit as well. So if you're here in Canada on the work permit, you're working, and the officer believes that maybe something isn't quite right, they could put a note on your work permit so that when you make another application for an extension, perhaps, they could potentially see that note in the system, and it may raise some further questions or concerns that the officer may put to you in that application. Obviously, for non-compliance, if the officer believes that you're non-compliant, there's also fines and penalties that may be issued depending on how severe the non-compliance is. And obviously all of that will be put towards your PR file as well. So that you could have 3 immediate issues that are very live. And so that's also something to be aware of when these compliance inspections start rolling out more frequently, which we do anticipate will happen probably more frequently during this year because of this theory of like enhanced integrity that we're seeing now. This is most likely going to be the trend for the next year, maybe even after that.
Alif, a couple comments. Thank you for the overview. One of the issues to keep in mind is that the officer, when they do have the review, they have wide-ranging authority to request whatever information they feel is relevant to the review. When these regulations came out in the traditional employer context, that's what many lawyers were concerned about. It's really important, if you do get one of these inspection letters, that you do seek counsel and you get an advisor to understand exactly what are they asking for, what is the impact of the information you're providing, and is the information clear in addressing the concerns of the officer. And what we noticed is traditionally they were looking at more objective activity related information, but we see here that they're looking again about the intention related issues, which when we go back to artificial transactions, it goes to the heart of the application. So if they do find on an inspection that there are any concerns, yes, as Alif mentioned, you could be fined, you could get a warning, you could be in fact subject to further audits and review. But if that occurs, keep in mind that that's a really significant red flag for your PR, and the officer would want to know why there were concerns or if there was a violation. It's very difficult to overcome that. So I think absolutely the 2 points Pushkar and both Alif have mentioned is whether it's landing, whether it's, the integrity of your filing, or even on an inspection. Integrity is going to be the theme, we believe, of this year, in checking to ensure that you're meeting the spirit of the program. The regulations, when released, they'll help us understand that even better.
Yeah, and just going off of best practices, like Naman mentioned, seeking legal guidance during these inspections is very important, because the applicant, you may not appreciate completely the questions that the officer is asking, because there may be deeper meaning towards what they're asking you, and it could have significant impacts later on. So if they ask you things like your activities, and you say, "Oh, I only just got to Canada, so I'm just starting to get the ball rolling on my SUV." Obviously the officer would maybe just make a note saying, they haven't been actively involved, right? And something as simple as that could be put into your PR application, which could have significant effects, negative effects. So it's important that you have legal guidance throughout the process, so that you have someone there with you who can guide you and kind of prepare you as best as possible for these inspections. And it's something that I don't think the entrepreneur should be handling by themselves, just because of the impacts that it may have later down the line on your other applications. And so some best practices, just going quickly through these: maintain detailed business records. So we have an activity tracker that we give to our clients. It has a list of all of the typical questions that the officer may have at the very beginning of your processing of your application. So things like, have you opened a bank account? Have you incorporated your company? Do you have any contracts with clients? Have you activated payroll? Things of that nature. Those are very common questions that you may receive within your first year of processing. So I think maintaining those records to make sure that you're prepared for a potential inspection, because again, they may give you notice, they may just come by your office. So it's important that you are prepared at all times. And so maintaining those business records is very important. Having an activity tracker, whether it's our tracker or your own tracker, as long as you're updating it on a weekly basis. Some clients even do it on a daily basis, depending on how active they are and how much they can show. But as long as you're revisiting it frequently and making sure that it's up to date, that will help you prepare for these compliance inspections. And it'll also help for your PR application as well, because you'll be able to show the officer everything that you've been doing. And you can even hopefully, if you answer the officer's questions preemptively by showing them all of your activities and progress, you could potentially cut down the processing time of your application as well, which is something that we've been successful in for some of our other clients. By showing these activities, we're showing that the business is legitimate and they're actively involved, so they should be approved earlier. And it has worked in the past. It's hard to say right now if it would still work, just based on processing times and the levels plans as well. But I think it's still a good strategy to keep in place because it will set you up for success. Whether you get a compliance inspection or not, I think it is good practice to have overall. The timeline is typically the first 2 years of time spent in Canada when you're operating your business. That's usually the focus of these inspections. So it is important to kind of hit the ground running and try to get as much done as possible within your first 2 years. The information and the activities that you provide after those 2 years will all be helpful for your PR application. But I think the scope for the inspections is typically the first 2 years. So I think that's where your focus should be. And again, seek legal guidance if necessary once you've received notice. I think it's always a good idea to have that legal opinion. They're actually opening up, well, they've opened up the work permits now. So now you get a 3-year open work permit. And so the previous work permit only allowed you to work for your startup company where there was an employee and employer relationship. Now you are able to obtain a 3-year open work permit, and you can work for any employer in Canada to supplement your income while you're here. The main consideration behind the introduction of this work permit was because processing times were so long that a lot of people had to continuously extend their work permits. Some people fell out of status. A lot of people were on implied status for months, and then they ended up losing their status, and they had to do a restoration. It becomes very messy, and it kind of puts more inventory into the system, and it slows down the whole process. So the 3-year open work permit was addressed to, it was introduced to address the significant backlog. And it was also introduced to address the fact that startup founders and startup companies may not be drawing a salary immediately once they're here in Canada. Once you've activated your work permit, it may take you a year or 2 years to actually start being paid from the startup company or to generate revenue. And so to address that, they've introduced the open work permit to allow you to work for other employers. Now, just because you're able to work for another employer to supplement your income while you're here, it should also be on your mind that you should spend a considerable amount of time still on your SUV company rather than working for an outside employer. So we typically suggest a 70% to 30% split of time, where the 70% of time you're working on your startup company and the 30% of the time you're working for another employer, or you're providing contract work, or just work on the side that helps you pay your bills and live your life in Canada. But that 70% I think is a reasonable amount of time that you can still spend working for your startup company. And the reason why we suggest this split of time is because IRCC and as Pushkar mentioned, CBSA, they are also looking at your activities and how much time you're spending committed to your company. So a lot of these organizations are kind of looking to increase the integrity of the program and the validity of your company, and to assess the validity of your company. And so if you're spending, let's say, 100% of your time working for another employer, then it speaks towards your commitment to the company, to the startup company. And so you have to be considerate of your time. You have to make sure that even if you're putting in, X number of hours out of the week towards, making ends meet and paying your bills in Canada, you really want to make sure majority of that time is spent on your startup company. And so the 3-year open work permit, I think, is great. It's something that a lot of people and stakeholders have been asking for under this program. So I think it's definitely beneficial. It has more benefits than negatives, I feel. But I think something to keep in mind is just keeping a track of all of your activities, making sure your time is divvied up appropriately. When the announcement was first made, when this was first introduced, you required an AOR, so the acknowledgement of receipt. You were required to have a permanent residence application number at the time you make your submission. They have since amended that policy, and now they've opened it up for anybody who is essential to the company. So if you're listed as an essential member in the letter of support, the commitment certificate, you are able to apply for the 3-year open work permit as long as you meet all of the other requirements like proof of funds, language test, ownership percentage, and you have a valid certificate. Another thing to keep in mind is that when you're making the application, you also have to make sure that you show proof that your PR application has been submitted. since you don't have an acknowledgement of receipt yet, the officer will be looking for proof that you've submitted your application and that it's in processing. So commonly we provide a screenshot of the portal, an email that you would have received when you submit your application, the PR fee receipt, things of that nature. Anything that speaks towards that requirement being checked off, it should be submitted with your application. So the 3-year open work permit, I think it's a great opportunity. Definitely look into it if you haven't already. And we've been filing these, it feels nonstop since October. So I think we are very knowledgeable on these work permits. So hopefully they start coming in, no issues, no problems. And once you have the 3 years, you can stay in Canada for the entire duration. And by the end of it, you should have your PR based on what IRCC's policy is. So I think it's a great opportunity.
We are going to be discussing some cases that have stemmed from the federal court. We're also going to be discussing some cases that either did not reach the federal court or were managed by our firm in form of case studies, to just show you what are the kind of issues that SUV applicants have been facing and how we've been managing them. So I want to, this is a very important matter that we want to begin with, Oroji v. Canada. So this was one of the last moment retainers where our firm was engaged only to argue the matter before the federal court. All the pleadings had already been filed, and a very unique situation arose in this case. The principal applicant had obtained a commitment certificate from a designated entity by the name of Karetsu. During the processing of the application, Karetsu withdrew its commitment certificate. The applicant approached another designated entity, Apex, and got another commitment certificate issued. The IRCC sent a procedural fairness letter, a letter to the applicant saying, asking about the change of designated entities and providing an opportunity to respond. The applicant advised that the initial designated entity was investing 75,000. Now they've been engaged by an angel investor who will be investing 200,000 into the business. The IRCC refused the application on the ground that the regulation requires that an application for permanent resident visa must be made within 6 months of issuance of the commitment certificate. This was challenged by the applicant before the court. And if you go on to the next slide, you'll see that we actually vehemently argued, Howard Noman had appeared before the judge and vehemently argued that if you look at the intention of the applicant, if you look at the amount of commitment, the amount of money that the designated entity is willing to invest into the business, this is going to be a successful business. That was the real intention behind the program, to get successful businesses operational in Canada. However, the federal court ruled that it was not unreasonable of the IRCC officer who reviewed the case to opine that the regulation is framed in a manner which does not permit changing designated entities midway through the process. Ultimately, the federal court ruled in favor of the IRCC, setting a very important precedent. That is, once an application for permanent resident visa has been made, after obtaining a commitment certificate, you have to make sure that you stay in regular contact and communication with your original designated entity, and you have to make sure that they do not withdraw their support in any manner, and you see it till the end. Because if they withdraw their support, and even if there's a new designated entity who's investing more money into your business, seeing its potential, even then the application for permanent resident visa may be refused under this program.
I have a comment there, Pushkar. It's an interesting, very interesting case. And I think for anyone listening, you have to always put your entrepreneurial hat and your immigration rules beside each other before you make a decision. Because any entrepreneur who gets an offer down the line to get a VC investment that's more sizable, that may be more supportive, that could allow faster growth, higher uptake, the ability to scale faster, most of us would take it. Right? It's intuitive that you would take that superior investment and the additional funds. But again, here, what I found very interesting when we were having the discussion and making the argument, it was acknowledged by the judge too, where she said, I may not agree with the officer, but I can't say that the officer was unreasonable in reading that provision that within 6 months, once you file the certificate, that is the certificate and no other certificate can supersede it. But what I noticed in the discussion was it wasn't necessarily that she agreed, and she said as much, but it was that the officer, when you look strictly at the way the provision was drafted, it was reasonable for that officer to take that view. What will be interesting in these new regulations is to see whether some of these issues that don't make sense from a business perspective, if they're embraced or covered by the regulations. But again, anytime you're going to make a material decision where there's an investment or looking to add someone into your team or potentially remove someone because of a disciplinary issue, do not do it until you get proper counsel about what the impact is, because this was not intuitive, but strictly reading the law, there was a position that was deemed reasonable. So it was interesting in that sense.
Right. Now, this other case is also very similar to Oroji. In this matter, what transpired is, and these issues are live issues. They're happening in cases that we are seeing before. In fact, a couple of months before this case and even after this case, we've been speaking with people who are undergoing the same issue. And our advice keeps changing based on the federal court judgments and the policy updates. So you'd find this case also along the same lines. There are 5 entrepreneurs who obtained a commitment certificate from an angel investor. All of them were essential members to the business. One of the essential members during the processing, because it had been such a long time during the processing, withdrew the application. The team pivoted and they decided, we don't need the 5th entrepreneur. The 4 of us can make it work. They went back to the designated entity and they said, please issue a new commitment certificate to us. Mind you, the applications for permanent residence had already been filed and the application was currently being processed. So they got an updated commitment certificate and updated it before the IRCC. The IRCC refused the application on the ground that one of the essential members withdrew their application during the processing. The applicant challenged the case before the federal court. And if you go on to the next slide, you'll see that the counsel in that case argued that, listen, the commitment certificate can be amended. Nothing stops you from amending a commitment certificate during the processing of the case because the regulation is silent on it. The federal court held that the intention behind that regulation, which states that if one or more members who are identified as essential to the business are either refused on the permanent resident visa or withdraw their application for permanent residence, then all the other members of the business will also not succeed in the permanent resident application, and ultimately denied the claim of the applicants and the applications were refused. You have to keep in mind, if you come together as entrepreneurs, whether you're 2, 3, 4, or up until 5, that's permissible under the regulation. If you're coming together as entrepreneurs, you have to stick together until the finalization of the application. Because if the application is withdrawn by either any one member who is identified as essential, then you can jeopardize your entire team. And it becomes even more incumbent if considering the fact that the application remains in processing for over 40 months. That's a long period. Personal circumstances, professional circumstances of members, their families may keep changing and evolving over time. So you have to make sure that when you're formulating this team of entrepreneurs, you make a commitment to one another that you will stick it till the end. Because if you don't, then all the applications may end up being refused.
So that's a great point. There are 2 takeaways there. One is know who your team members are and make sure everyone understands the rules. Unfortunately, we've been engaged by many people midway, and they've already made substantial changes where people have come and gone and new people have made new applications and their different certificates. It's a real mess to unwind. And when you look at the federal court, in many instances, if they apply the precedent, there's very little room to be able to repair the circumstances once those changes are made after the filing of the PR. And the second point is also picking your designated entity. And know that it's like a marriage. You're not able to just swap a new one after, and you shouldn't do that in marriage either. But you shouldn't be just moving over to another designated entity. You have to be understanding that once you file, you're in it with them. So both in picking your team members, it's really important that each person appreciates the consequence of being in a team and what the implications are to one another. And similarly with the designated entity, make sure that you have the support and that their processes, you live with their processes. We're going to talk about that. But even the way that they transmit and they share and save information about your file, everything has to be on par, because these are factors that you live with.
Actually, I was reading the comments and I read a very interesting question. It says, if there is a change to the commitment certificate, change of a team member that was made in 2023, will it still be the case that the commitment certificate will be treated as frozen? We'll address these questions, but it stems from the same issue, that these are live issues, and we have to make sure that you, as a client, I think it's very important to make sure that you're consulting with a law firm and advising them about what these changes are and why you're wanting to get these changes made. We've been advising a number of people on such issues, and I think that the changes that you make today, when the application is processed 3 years from now, the impact will be then. So you don't want a situation where you're in Canada working on your business, creating your business for 3 years, and the application is ultimately refused after 3 years. So consult with a lawyer today instead of facing the consequences down the line. Moving on to the next one. This is Buey v. Canada, and a number of other judgments all stem from the same issue with respect to artificial transactions. There is a provision under the Immigration Refugee Protection Regulations, that is 98.12a, that talks about what are the requirements of the program. And there's another provision, 89, that discusses that as an applicant, you have to make sure that you're not applying under this program to gain permanent residency as your intention. Your intention should be to establish the business, and in lieu of that, gain the benefit of permanent residency, and not vice versa. Now, of course, the federal court also rightly puts it. It calls it that there is a very fine line between immigration being motivated in part by the economic motives and participating in the immigration program primarily for the purpose of acquiring status or privilege under the act. And you have to make sure that you stay above that line. That is, your primary intention should always be to establish the business. Now, how do you prove that? You prove that by creating more and more activities of your business, by progressing your business. And Alif has explained, and so Numan has also talked about this. You have to make sure that you keep progressing on your business. You have to keep pushing towards more client meetings, selling your product or selling your service, and keeping a track and record of all of this, so that the officer does not frame that opinion. We can go on to the next one. Another question that I read from one of the participants is that I created my business plan myself, and being not expert in that, it may have some gaps and it's not fancy like consultants make. We agree with that. I mean, some of them are really fancy. It could be an issue. Yes, I mean, depending upon, we'll have to review your business. And that's why when we start talking about the business plan, it's very important to make sure that the business plan is not just merely an outline and does not just, simply throw in what your business is and describes your service and that's all. It has to be very comprehensive. And the federal court has also recognized this in the case of Ajili v. Canada in 2023. And further from there, we've seen a number of cases that we've been filing that, clients have approached us where their applications are on the verge of being refused on procedural fairness. That, we've noticed that there was at times no business plan, not even a pitch deck. And in some instances, we've noticed that there is a business plan, but it's like a Word document created by ChatGPT. I think that, you must leverage GPT, and you can leverage a lot of different technologies to create the business plan. But the business plan primarily should at least identify the product. It should describe what the service is, what you're trying to create. It should describe the uniqueness and innovation, considering the Startup Business Class program is for unique and innovative ideas under the tech sphere. You have to make sure you identify the revenue stream, what is the cost associated with it, what are your milestones that are going to be in the next 3 to 5 years. So your business plan essentially should be created in a manner which is a pitch that you're giving, elevator pitch that you're giving to an investor who you want them to invest in your business. And if you keep that in mind, if you keep that background in mind with respect to having a very comprehensive business plan, then you should be safe in effect. But if your business idea, like the federal court puts it, is in effect an idea that was never really fleshed out in the business plan, then it's likely that your application may be refused just on that ground. So you have to keep in mind to make sure that you engage professionals to get a very comprehensive business plan made.
One of the services we provided that's been very welcomed from people who may have filed their application and then realized, and many of you might realize after you hear the discussion, the standard's very high. And there's a lot of requirements that you will be asked to produce, whether it's through inspection or additional documentation requests, or potentially even if there's concerns at a procedural fairness level, is what we do is a health check. And it's exactly that. We look to see, does the business plan, is it comprehensive? Does it make sense? Are the people in the business, have you described your appropriateness in each one of the roles that you've taken? Have you actually made the case that you have the experience, you're capable? We've seen cases of procedural fairness where the officer just wasn't convinced that a person could execute a role. And some instances, and our heart goes out to people who decided that they would do it themselves, and they tried their very best, and they followed the list of documents, and they thought that they did everything, and they assumed that the program was kind of straightforward. If you had a certificate, the language scores, the settlement funds, the shareholdings, well, you complete the form, you file it, and you get your PR. The standard, and that's what today's discussion is about, the integrity and the expectation is to make sure these businesses are real, that they make sense, that they've been selected appropriately, and there's evidence of them being able to perform at a level that would be expected for someone who is truly committed to the business. The good news for anyone who's hearing this and is having a little bit of a heart attack is that we've done this quite regularly. We can go in and we can rebuild, and we can advise and update an application, and then get the clients ready to understand, especially if they didn't fully appreciate what the expectations are, is to counsel them and give them advisory on what the requirements are. And you often can then up your game and deal with those gaps. And then, we've had many people in that situation where by the time we were done and working with them and they really rolled their sleeves up, they were able to get their PR. But if they left their applications in the current state, it was, a problem waiting to happen. So I think it's really important that you do get that second opinion if you're unsure about the quality of your representations. We'll give you a flavor of this slide. It's something you can definitely look at. These are a number of hot topics that are happening in the world of SUV processing. We'll pick out a couple ones that are really hot these days. We saw a flurry of work permit refusals, and individuals came to us suggesting that they were asked to produce a brand new, fresh letter of support to apply for a work permit. And the reality is it's not required. And in fact, it was confirmed by the designated service channel 2 recently that it's not required, but unfortunately there are officers that are asking for this information. And so what's important here, and I'll just kind of loop in the issue of dual intent. We also see a very common refusal ground on work permits where the officer is concerned that the individual will not return after they arrive in Canada, notwithstanding that it's a PR program and the intention is ultimately to get PR, and there is case law on point. But in both of these situations, the message here is when you prepare an SUV work permit, you have to anticipate that the audience needs guidance, and where you can integrate policy and directives as well as case law we do that in our applications and provide a guidance for the officer so that it's more likely that they'll be able to make sense of the process. Hopefully, when these new regulations are released, there could be more clarity, so it's not necessary, but this is what we've done through experience to make sure that we have the best chance of success. But you may very well get a letter like that, and the entities often won't issue a new letter of support because they issued the certificate previously, and that's when the letter of support's issued, and that's not normally their process. It creates some confusion. So just know if that comes up, it's not a hard stop. There's a way to deal with that, and we can definitely help you with that. Pushkar and Alif, why don't you pick one or two of these that you want to comment on, and then we'll get into the best practices. If there's anything hot topics you want to touch.
I want to actually discuss transmission errors on certificates. That's one of the many cases that we've been litigating before federal court. Unfortunately, what has transpired, some designated entities forgot to send the commitment certificate to IRCC. Somehow within their departments, someone was tasked with sending the commitment certificate via email, and they forgot to send it. And what transpired from there is that a series of applications under the Startup Business Class program for that designated entity and the applicants started being refused. In some of the cases, we've challenged it before the federal court, explaining the circumstance. In other cases, we've tried to do reconsiderations, but it's very important to understand that the Startup Business Class program has a couple of different key players. One is a designated entity that will support you in your business, that has to incubate you. The other is, of course, you as an entrepreneur who has to keep making a progress of the business. The third is, your legal representative. You have to make sure that you have all three that are doing their job correctly, because sometimes for no fault of your own, the application may be refused. And once it's refused, then it's a very important element that the Startup Business Class, the commitment certificate under the Startup Business Class is sent to the IRCC. If it's not sent, then the IRCC can refuse the application on that ground alone. We've seen a number of such cases before, and it's very unfortunate that these issues are rising, but we've been litigating these issues before the federal court, of the non-transmission of the commitment certificates. At times, an incorrect commitment certificate is sent, a draft version of the certificate which does not have all the information. So all of those aspects you have to consider to make sure that sometimes the applications are refused not because of something you didn't do, but because of a third party who had to act on your behalf and did not complete the progress. So make sure you choose your designated entities carefully. And I think that's my
well, maybe I'll add on to your point. You are definitely in a relationship with whoever you pick to prepare your file or consult, if it's a business consultant or if it's your legal representative. So even inadequate due diligence, you present your case, but it's up to the entity to make sure that they've done their job. And I think that's what we're going to see. In fact, that's one of the questions going around right now from IRCC is, how do you do your due diligence? And wouldn't be surprised if they start establishing a standard for review. Be careful too, if you're in the community and you're approached by a business consultant about being matched to a business, like that's a potential flag too. So be careful about the advice you get from third parties. And then we've touched a little bit, we do believe there'll be enhanced compliance. So you could expect more reach outs, whether it's inspections. We've had IRCC officers call SUV applicants randomly and ask them very pointed questions. And, very shortly thereafter, procedural fairness letter gets issued. So the landing issue, we know that that's become a hot topic too. So generally, all of these issues, all the decisions you make, who's essential, who isn't essential, who you should add to your team, if you're going to change your business plan or update the business plan. We see guidance from the federal court. Hopefully you've all taken note of that once you file one application, you're locked in, you can't change that certificate. But these types of considerations you see on the screen, these are the things you need to think about to make sure you can navigate the SUV program. I want to make one comment. If you're genuinely committed to your business, you have a great idea, you're working hard, you're documenting, you got the right team, you don't have anything to worry about. people get through the program and they do very well in Canada. It's where you miss one of the key partners in this process where you can run into trouble.